So to start us off, I always start with a bit of some history of the regulation that the MRA is tasked with implementing. So in 2008, we had the Michigan Medical Marijuana Act. This is the Patient and Caregiver Registry and is a registry program that requires physician certification to qualifying debilitating medical conditions. In 2016, saw the Commercial Licensure and Regulatory Program under the Medical Marijuana Facilities Licensing Act and the lesser discussed but very important Marijuana Tracking Act as well implemented. Some data. Currently, we have 2,303 pre-qualified entities. 1,253 licenses have been approved, and these are for provisioning centers, growers, processors, secure transporters, and the safety compliance facilities. I have the data on the screen there to see the numbers as of last month. The MMFLA is a municipal opt-in law, contrary to the 2018 Michigan Regulation and Taxation of Marijuana Act. This is our adult use licensing act, and we currently have, since our implementation, we launched November 1st, 2019, we have 1,027 pre-qualified entities and 847 licenses approved. As I'll outline a little later in the presentation, as you might note, in comparing the 2016 information and the 2018 information, we have some different licenses that are on the screen. So we have our standard growers, processors, the marijuana retailer, the transporters, and the labs, but we also have micro businesses. We have since licensed 6 micro businesses. We have 16 marijuana event organizers, and we have held 3 temporary marijuana events. We have additional license types lumped into the grower category. We have the excess grower, and as indicated, we have the marijuana event organizer, temporary marijuana event, and a designated consumption establishment. Licensing objectives. So our goal is to process applications for state licenses for these marijuana establishments, conduct the background investigations, and make a licensing determination. The licensing process should be concluded with the state license issuance or a notice of denial being served within 90 days of receiving a complete application. Unlike medical, the MRA statute tasked us with a statutory framework with which we must make those licensing determinations within 90 days. So the licensing process is that we make that determination within 90 days of a complete application. We consider that complete application to be a submission of a step 1 pre-qualification and a step 2 establishment application coupled with the required payments. In addition to the licensing components that you'll interact with specifically within the licensing division, there is also coordinated efforts. This would include the, for some instances, the social equity program. It would include MRA enforcement. That's where we would see inspections occurring or investigations needing to occur. The Bureau of Fire Services, again, fire safety inspections. Michigan State Police for criminal background checks. The Department of Treasury. They're a part of our application with an attestation that must be signed by Treasury. And currently Raymond, who does our financial background checks. The application process that I'm speaking of is a 2-step application process, with the first step being pre-qualification application. The pre-qualification is where we look at the entity, the main applicant, who will be seeking to hold an eventual license, and all supplemental individuals, supplemental entities, managerial employees, spouses. This is where we consider the people, and that could be individuals, then that could be subsequent supplemental entities that could be involved in the people that are in those entities. We also, if you're not seeking pre-qualification as an entity, you're not seeking it as a LLC or a corporation, you could be seeking to apply, so holding that eventual license in your own name as a sole proprietor. So that's more of an individual application. Those are our 2 main applications, the entity and the sole proprietor option. With that would come then the supplementals. You would have potential managerial employees, individuals with greater than 10% ownership interest being considered an applicant, and spouses. Spouses are considered supplemental applicants and would be required to submit application for the supplemental spouses that they're along on the application with. When I speak of a managerial employee, I'm talking about those that have the ability to control and direct the affairs of the marijuana business, or have the ability to make policy concerning the marijuana business, or both. This is a term that is defined in our rules. So I would encourage you to reference the rules for the definition of applicant, for the managerial employee definition, and to shed some light on who we consider applicants. And when you're considered an applicant, you'd be required to submit that supplemental application. You would be required to provide, submitted for background investigations and MSP criminal history background investigations. So the background investigation process is kind of two-pronged. We have your MSP criminal history investigation, and under MRA, there is one automatic disqualifying conviction that would be of note, would be distribution of a controlled substance to a minor. They would also be identifying additional convictions that may be taken into consideration. Raymond provides our financial investigation. This is going to look to litigation history. It's going to look to any tax liens. It's going to pull items that would be required to be disclosed on the application that maybe failed to be disclosed. You failed to disclose a marijuana business interest that you have an interest in, or you failed to provide a piece of litigation. So those are information that the background investigation is looking to corroborate the information that is provided within the application and identify pieces that perhaps were left off the application. That comprises a background investigation. A touch point you'll have with the analysts that are processing those applications is going to come via a notice of deficiency. This is applicable at step 1, which I've just discussed, or step 2, which I will get to. The initial notice of deficiency, the NOD, is issued after application review, and it's issued for discrepancies in the application where there is missing or incomplete information. There could be something as straightforward as a name being left off of a field on a disclosure within the application. That is going to be something that would result in a notice of deficiency. It could be something where it didn't provide a date range for litigation that was required to be disclosed. There's information that maybe you started to complete but didn't complete all the way, or there's missing information that was just never completed in the first place. Whatever the case may be, the NOD would be issued in an attempt to gather and finalize all the required components to that application. And it could be something that you completed the disclosures, you completed the attestations, the actual application piece, but perhaps failed to provide a piece of supporting documentation. You failed to provide a social equity plan in submitting that application. That would be something where you would receive a notice of deficiency for that. The notice of deficiency will communicate that you have 5 days to respond to the NOD, or it could be subject to a denial. Timeliness in the process is very important. So as I indicated, we have 90 days to process the step 2 application to issue that license. But in considering the time in which we are tasked with having to complete the licensing process, we extend some of that back onto the applicant to ensure that these applications are moving forward, that they are timely being processed, that the inquiries that we are making are being responded to in a timely fashion. So I encourage careful response to NODs that you receive. And even in the event to where you are unable to provide all the information to that NOD, at least staying in communication with your analyst, keeping us advised of the situation you are in, it helps us to help move those applications forward, or at least know what the circumstances are. You will be followed up with. There will be, repeat NODs sent, phone calls made, so the communication doesn't just stop with just the submission of that NOD. We try to make a conscious effort to get it worked to completion. You could also receive a notice of deficiency as a result of the background investigation. So based upon the reports we received from MSP or Raymond, we could say that there is something that was not disclosed on your application. And we are following up with you to resolve that piece of non-disclosure, the circumstances surrounding it, the reason for it not being disclosed upon initial application. So that would be another avenue in which you may see a notice of deficiency submitted. And just as these could be submitted for the step 1, they could be submitted for the step 2, these initial notice of deficiencies. The step 2 application process. So step 1, as I said, is the pre-qualification process, and that's where we're concerned with who comprises that entity structure, be it the entity, be it the sole proprietor, who the spouses are, who the managerial employees are, and conduct the background investigation. So that is focused on the persons. The step 2 application component is focused on the actual marijuana establishment, where they will be operating, inspections that need to occur, both Bureau of Fire Services and MRA field ops. It's concerned with the supporting documents that would be relevant to that actual brick and mortar establishment. The establishment types you could apply for are the grower, and that's class A, B, or C, a marijuana processor, the marijuana retailer, which is the counterpart to the provisioning center over on the medical side, a marijuana secure transporter, the safety compliance facility, and a micro business. The marijuana micro business, that is the license type that is a self-contained license type where you are able to grow, process, and retail all within that one license. The designated consumption establishment, an excess marijuana grow, the marijuana event organizer, which is the license necessary to then lead to a temporary marijuana event. Those are available under the step 2 process under the adult use licensing. The process involved for that step 2, we are looking to the things specific to that business. We're looking at proof of financial responsibility, the insurance required to be provided for that application that indicates that you have the necessary insurance in the event of a product's liability or claim that comes from the result of adulterated marijuana. We're looking to municipality information. MRA, as I said, is an opt-out ordinance driven piece of legislation, and it is such that the municipality must not have opted out, prohibiting that adult use marijuana establishment from being within that municipality. And there's an attestation that would be required to be submitted where the municipality acknowledges if they've opted out, and the fact that the establishment is not in violation of any zoning or ordinances that are specific to that location, that business. We're also looking to gather general employee information. We gather plans as to your marijuana business location plan and the other supporting documents that are outlined within our application. The physical marijuana establishment must pass an inspection by both MRA and the Bureau of Fire Services within 60 days of submission of that application. So a 90-day process. By the 60th day, we ask that you have passed your required inspections. This keeps us moving forward to timely get those applications processed with that licensing determination being able to be made by the 90th day. Your failure to get that passing inspection by the 60th day could result in the denial of that application. And I would say that in some instances, and rather than seeking a denial of an application, we'll have applicants that may be in a position where they're unable to, they don't have everything in order for the inspections and their time is running out, that they choose to withdraw the application. And withdrawing that application doesn't negatively impact then a future application being submitted. So if you're unable to meet these time requirements, if you withdraw the application and submit a new one, your clock would start over. You would have that fresh 90 days. Whereas the denial of an application, that could negatively impact that applicant going forward. We encourage that the applications aren't submitted until you are in a position to be able to make that passing inspection by the 60th day. So this is something that is a comparison to MMFLA and MRTMA. We've seen that some applicants who are doing entirely new building structures, entirely new build outs to their brick and mortar location, may not be in a position to have that passing inspection by the 60th day because, delays in building or needing a local inspection to occur before they've obtained their certificate of occupancy. Those are the types of considerations that you'll want to look to when determining when's the appropriate time to submit that application, just to ensure that that application is, upon submission, able to move forward timely enough. I would also point out that there is another touch point with Bureau of Fire Services in addition to just the necessary fire services inspections, that a marijuana grower, processor, designated consumption establishment, and microbusiness are required to also obtain Bureau of Fire Services plan review. So those application types would receive a notification from MRA that they can supply to the Bureau of Fire Services and seek to have the plan review conducted by BFS directly, so that your application process continues to move forward. One piece with the Marijuana Regulatory Agency and one piece with the Bureau of Fire Services, ultimately resulting in inspections occurring, hopefully passing inspections occurring in a timely fashion that lead to then a licensing determination able to be made. I have on the screen now some of the initial licensure fees for the various license types. This is also outlined within the topic-based rule sets in the marijuana licenses rule set. You can find these specific fees. I will pause a second here so you can take note of some of these fees. I would note that they are a initial licensure fee. It's a fee that's issued upon approval of a license. So you pay your $6,000 pre-qualification application fee for step 1. You submit your step 2, and upon approval and a licensing determination being made favorably, you would be invoiced this initial licensure fee depending on which license type you are seeking. So the fee on that step 2, the fee for the license, isn't actually assessed until the determination is made. Of note, the temporary marijuana event is a pronged fee. There is a per day per licensee participating calculation that goes into obtaining the temporary marijuana event fee. Again, these are in the rules, and so I would encourage you to take a look at the various fees that are outlined in the marijuana licenses rule set. Common application issues. I have on the screen some of the common issues that we see, and I'll kind of walk through them. This is usually an area where questions typically may arise. So I'm happy to address questions about these later on as well if you're coming up with some questions here. Inconsistent organizational documents. So we may see that a main entity application could be submitted for a limited liability company. Upon review of the documents that are required to be submitted, your governing documents, your organizational documents, it may appear then that there is references to a corporation. And upon reviewing the CSCL over in Lara, the filing that is made with them in terms of what your entity is, we could see that, in fact, it truly is a corporation. So an application has been submitted now for an LLC when in fact it's a corporation. So making sure the understanding of what the entity structure is, and then the necessary documents that go along with it, and that is all submitted accurately at the front end is very important, because that's going to be a significant area where we could see applications needing to be withdrawn and started over with a new filing. We could see applications receive significant deficiencies that then need to be resolved. So making sure that the organizational documents submitted match the entity structure for the main applicant that is applying. And then that also goes for all the supplementals. So if there is a supplemental entity involved, say another LLC, and then that leads to individual owners, making sure that we have the correct supporting documentation for that LLC that may have ownership in the main applicant. We do look to these organizational documents upon reviewing the application. They are out on the checklist. I encourage everybody to go to the website, michigan.gov/MRA. There is an adult use establishments tab, and there you can find the online application instructions, the paper applications in different forms. In there are some step-by-step application instructions. There are resources so that you can navigate if you're applying as an LLC, what then would be expected along the way. And then what is expected as you navigate the Excel system for uploading all these documentation and submitting the application. The checklist is one of those things that you can find out there in the paper application forms section. And within that checklist, you can see the organizational documents that we would be requesting of the entity. And if you have questions or concerns about what is being asked, what we are going to be reviewing, I would encourage you to contact our agency. We have a great customer service section that can address the concerns you may have. If any of our instructional materials, educational resources leave you still having questions, I would encourage you to ask those questions before the application is submitted, making sure that those things are clarified before you get in the queue of process. That will help to mitigate the deficiencies that may stem from inconsistent documents. And of those documents that are on the checklist that we request to be submitted, making sure that the name is the same across the board. As a individual that's processing your own application, you may put your name on things when really it needs to be the entity that is going to hold the license. You may be the sole owner to that entity, so it's easy enough to insert the incorrect name in various places, but making sure that it's consistent across the board of what's the entity, who's going to hold the license, is it an LLC or a corporation, and supplying then the appropriate documents pursuant to that checklist. Lack of complete supplemental applications. That's another area. If you're a main applicant applying as an LLC, you would be required to submit applications for everyone who is considered an applicant. Again, I would encourage you to review the rules for the definition of an applicant. For those that have greater than 10% ownership in that LLC, for the spouses of those individuals, and to determine the managerial employees who are all applicants. Anyone who is a applicant would be required to complete a supplemental application. That could be an entity supplemental application, if it's an LLC that owns your interest, or it could be an individual, if the individual owns it in their name outright. Making sure that we receive those supplemental applications that are complete, that contain all the supporting documents that are laid out in that application checklist, is going to be important to keeping that application moving forward and to mitigate the number of NODs that you would receive, the notice of deficiencies that you would receive. On the step 2, a consideration of note is missing DBA or certificate of assumed name. So the DBA is the doing business as, that's a county level filing. So you could be company X doing business as great company. And if you don't have that properly documented, the name you're going to put out on your storefront, the name you're going to transact business in, other than your legally filed name, that's going to be a deficiency within that application. So at the county level, you can obtain your doing business as. The state level, you can apply for at CSCL and obtain your certificate of assumed name, making sure that those names that you are going to transact business in are documented within the application, and the appropriate filings are provided as part of that application will be an important piece to keeping that application moving forward. So if you're using any other name to transact business other than what is your legally authorized entity name, then you would need to submit the DBA or certificate of assumed name for that. We also sometimes see issues in terms of sole proprietor versus entity submissions. So this is an area where an individual may submit the application in their name, thinking they're an individual, they're going to be the one to hold the license. But then they want to operate as ABC company. That's actually not a sole proprietor application, that's an entity application for ABC company. If ABC company is the main entity and the one that's going to seek licensure, ABC company is our main applicant, they would be required to submit the main application. And that individual that owns ABC company is who's submitting the supplemental applications. And for everyone that's an applicant, that's who would be submitting supplemental applications. It's an area where we sometimes see then applications have to be withdrawn, they start over, they have to switch from a sole proprietor to an LLC, or from an LLC to a sole proprietor. There's times where they realize they don't want to use the business that they have filed out there, this other LLC, and they actually want to operate as their individual name. So making sure that you're embarking on the application in the appropriate fashion from the beginning will ensure that that application continues to move forward and has limited deficiencies that may follow. Failing to respond to deficiencies timely, that can be a common application issue. As I indicated, there is 5 days with which we ask that you respond in full to your notice of deficiency, or there could be a resulting denial. And the failure to respond to those deficiencies, or to at least provide updated communication of where you are in the process. It's a matter of you're trying to track down a document and it just takes you more than 5 days to get that document. Letting us know that at least lets us know that you're still actively working on it. You don't have questions about what is the expectation or what it is we're asking for. So responding to those deficiencies in a timely manner really keeps those applications moving forward. Delays in the background investigation due to COVID-19. So we have seen that there were some delays in our pre-qualification process due to COVID. And we would like to think that those things have started to resume and things are moving at a more efficient pace. But I would just encourage keeping us up to date on communications. I know we've seen some delays that are a result of building delays. But with that in mind, we still have a timely process we have to follow. So obtaining your passing inspection by the 60th day of a 90-day process, unfortunately, and we know that there are delays, some within and beyond your control, but once you embark on this licensing process, making sure that things continue to move forward towards completion, and we're mindful of the fact that we do have a statutory time frame that we have to get this stuff completed by, and that is licensing determinations made within 90 days. On the screen now is the contact information. So if you have general inquiries, if I've put something on the screen that leaves you asking questions, please feel free to reach out to MRA-adult-use-marijuana at michigan.gov. This is also able to be found at our website, michigan.gov/MRA. And I put the phone number on the screen here too. I would say if you're going to have a touch point with MRA, you're seeking to become an applicant, a licensee, or you represent applicants or licensees, that also signing up for our email notifications, that will help you to stay up to date on all the new and changing information we put forth. That will keep you apprised of new bulletins that get released, updates to our website. Unfortunately, when we have to do product recalls and the like, those sorts of public health safety information, general educational information, that is all available on our website. And there is a ton of information out there. So I definitely encourage you to take a look at those resources. And where then there's something that's just not clear in FAQ that doesn't go far enough, then by all means, please reach out to us and we can be happy to address those questions. Once you get into the licensing process, you'll be receiving an analyst that will process your application, and they will be in communication with you directly. So you will have an individual that you can reach out to navigate your specific application. So that then email on the screen is for the more general inquiries.